Welcome our next witnesses from the Animal Defender's Office, I believe.
Yes.
Could you, each witness, state their full name, the capacity upon which you're appearing before the inquiry, and then take the oath or affirmation, and I'll start on my left, your right.
Thank you. Tara Ward, Executive Director and Volunteer Lawyer with the Animal Defender's Office. Thanks. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
I'm FARNHAM Seyedi. I'm appearing as volunteer lawyer of the Animal Defender's Office. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Okay, now would you like to make either of you would like to make a brief opening statement?
Yes.
Thank you. We each have one, but they're very short.
Are they written and prepared?
Yes.
Yes.
Because the people on your
Yes,
right would love it if you could furnish them with a copy. It makes their job easier.
Yes, well, I think at least mine is, but we'll
Okay.
do it that for the second one.
Okay.
As soon
Away
as
you go.
possible. Thank you. So thank you for the opportunity to appear before the committee. I thought I would give a very brief history of animal cruelty laws and their enforcement, just to put the system we have today in some kind of historical and cultural context. So the first laws resembling our anti-cruelty laws as we know them today emerged in the early 1800s in Britain. There were a few failed attempts to bring in what would have been world-first legislation to protect animals. Finally, in 1821, Richard Martin, who was a lawyer and a member of Parliament, successfully introduced an act about protecting cattle. And this was the first act protecting animals to be passed by any state anywhere in the world. The problem was, however, that there was no police force to enforce it or to prosecute offenders, as the Metropolitan Police Force was not created until 1829. So Richard Martin himself was involved in the first prosecutions. He also established a society for the prevention of cruelty to animals to support his act through inspections and education, as well as setting legal precedents through prosecutions and to bring about further cultural and legal change. So it is useful to reflect on the origins of our anti-cruelty regulatory framework, which was radical at the time, but that was 200 years ago, almost to the year. So we would suggest that having private charities enforce animal cruelty laws today in 21st century Australia is nothing but an historical anachronism which has no place in today's modern society. And I'll now hand over to my colleague, Mr. Seyedi.
Thank you, Tara, and thank you to the Chair and to the committee for having us here today. So the Animal Defender's Office is a nationally accredited not-for-profit community legal centre providing legal assistance, representation, education and advocacy on behalf of animals in Australia. The ADO endorses the acknowledgement of animal sentience in the ACT's Animal Welfare Act, which states that animals are sentient beings who are able to subjectively feel and perceive the world around them and have intrinsic value and deserve to be treated with compassion and have a quality of life that reflects their intrinsic value. It also states that we humans have a duty of care for the physical and mental welfare of animals, which we endorse. As such, we recognise the work done by many organisations around Australia and within New South Wales with the laudable goals of preventing and investigating the infliction of unnecessary suffering on animals, including but not limited to approved charitable organisations within the meaning of the Prevention of Cruelty to Animals Act. We do not, however, agree that charitable organisations should be the main enforcers of the criminal laws and sanctions contained in the Act, whilst at the same time maintaining their status as private entities. We suggest to the committee that in most circumstances the community would not accept law enforcement agencies such as the police having to rely on private donations to fund their day-to-day operations or their law enforcement functions, while at the same time having limited accountability regarding the exercise of their significant powers. Indeed, we submit that having such an enforcement system in place in any other context, particularly for violent crimes, which many animal cruelty offences do constitute, would rightly be regarded as patently absurd. To our knowledge, the exercise of criminal law enforcement powers by private charities is unique to animal protection in New South Wales and other similar jurisdictions in Australia and overseas, the result being that these private entities exercise these significant powers without mechanisms for systemic accountability, which our case studies and others you've heard about during this inquiry demonstrate, that there is no fundamental accountability to the community. without levels of transparency and accountability that would normally apply to public institutions. In particular, we disagree with the view that private charities are subject to the Government Information Public Access Act, or GIPA. We submit to the committee that these systemic flaws are not insignificant and that the structure of the animal cruelty enforcement framework fundamentally fails to protect animals in need. The community of New South Wales, including the millions of animals who endure so much suffering at the hands of humans, deserve better. We submit that an alternative framework for animal cruelty law enforcement will need to be based on 4 key principles, that being transparency, accountability, independence from government and industry, and sufficiently resourced and capable to enact their duties. Whatever can best achieve this, whether it be an independent statutory authority or a specialist unit within the New South Wales Police, is one we would in principle support and endorse. Those are our submissions. Thank you.
Thank you.
Thank you.
Mr. Chair.
Actually, Mr. Veach is going to
sorry.
Thank you.
Thank you for your opening statements and your submission. Can I just go to page 14 of your submission that you've presented to the committee, where you say, and I quote, the current animal cruelty enforcement framework lacks appropriate oversight mechanisms and is not subject to sufficient public scrutiny. And you go on to say about enforcement powers. Just taking that bit of your statement.
So elaborating on...
You elaborate that. So you've talked about GIPA.
Yes.
What about parliamentary scrutiny? What are the measures you would like to see in the perfect world for this?
The same that would be expected of those exercising executive power, especially those that are coercive or have criminal sanctions, including terms of imprisonment, similar to that of police or at least other independent statutory authorities or other executive departments. That could include parliamentary scrutiny or at least information that is routinely expected to be published to the public. We know that there are annual reports provided to DPI, but not necessarily public to the public about the inspectorate's operations.
Mr. Drops, are you suggesting those reports should be tabled in Parliament? Is that what you're suggesting?
It really should be published on their website as like an annual report would.
Okay.
But can be tabled in Parliament as well, certainly. In terms of accountability, that's referring to where there are any misuse or abuse or even allegations of misuse and abuse of power that can be instances of those who are dissatisfied that powers weren't exercised at all when they should have been, or that they were not exercised appropriately. Our understanding is that, and the RSPCA, and I believe, at least in the RSPCA's submission regarding their own levels of accountability, they referred in their submission to judicial scrutiny of their prosecutorial activities. We would suggest that wouldn't be sufficient, although that is an appropriate check and balance. That's okay. What we all go through under our
my second
law.
question, everyone else is busting for questions as well, and it's
Of course,
a
sorry.
truncated time frame. So my second question actually relates then to GIPA.
Yes.
Now, a number of people have said that the agents, the ACOs, AWL and RSPCA, because they receive government funding, should actually be required to provide information on GIPA. Can you explain to me what sort of information would you be looking for, and why is that important?
So, for example, I think in one of the case studies in our submission was about a particular case where we were instructed by our witnesses to a particularly what can I say, horrific or case of cruelty to many young vulnerable animals, and we provided the relevant enforcement agency, with being a private charity, with a comprehensive complaint setting out every possible or a wide range of potential offences and breaches of the Act, the regulation, codes of practice, etc., industry standards, etc. And we got that complaint went absolutely nowhere, and that would be an example of where it would be great to be able to find out what happened to that, why it wasn't investigated, or if it was investigated, what was the outcome.
Sorry, more holistically as well, often when there are evaluations such as parliamentary inquiries such as these, but even academics who are trying to do evaluations of our animal cruelty laws around Australia to see how they are performing, they would often want a breakdown of statistics, for example, like how many complaints are received, how many get investigated, how many move on to prosecution, and when prosecuted, how many are successful and what the penalties are, for example. And although charitable organisations have provided that information from time to time, it's certainly not routinely done, and it's certainly not provided, to my knowledge, as part of annual reports with relevant approved charitable organisations. So it would be information like that as well.
And the detail, it would be the detail. So there's a broad level of information that is provided, but it's the detail, breaking down those the statistics that are given, so that a proper evaluation of the regulatory framework and whether it is working and achieving its legislative goals is very difficult under the current situation, because that information is just simply not available. For example, what penalty infringement notices are actually given for, what offences, so we can see where they are useful and where they're not useful, or what offences were the prosecutions for, what were the outcomes, what were the sentences. Much more information like that would just enable the community to be able to evaluate the regulatory framework, including the enforcement aspect, which is critical, to determine whether it's achieving its goals.
Thank you very much. I've got a lot more questions, but so does everyone else. So,
Mr. Banasiak.
Thank you. Just seeking some clarity on some of your commentary around the powers that currently exist with RSPCA and potential powers that you may propose. On page 6 of your submission, you state that the RSPCA doesn't have the powers that the police does, and you would like them to have the same. We heard evidence from police and DPI yesterday that basically stated that the only difference between the police and the RSPCA in terms of inspecting potential animal cruelty is that they can wear body cameras. Would you refute that evidence, or is there other things that you see that RSPCA New South Wales doesn't have that police do?
So I didn't hear the evidence provided about the body-worn cameras, but I thought that both types of officers would be able to use that, and we've seen instances where they have. So I'm not able to comment on that. But one example, if this is going to your question, one example would be surveillance powers. So what we see is often that animal cruelty or abuse or neglect of animals happens behind closed doors, no access to the public, and the only way to be able to obtain evidence of that cruelty, short of whistleblowers, which unfortunately doesn't happen as often as it should, could be, for example, surveillance devices or surveillance powers. Now, we've seen the very regrettable and unfortunate consequences for the criminal prosecutions process and the criminal justice system, where prosecutions rely on, let's say, improperly obtained evidence.
That goes to my
Exactly.
next question. In your submission on the same page, you stated that there was evidence against greyhound trainers where the cases of
Gretchen Kadir.
Yeah, they used that undercover footage, but then it was ruled inadmissible because it was obtained illegally. Now, I want to, get clarity on what you're proposing. Because I don't think you're proposing as legal professionals that we ignore the rules of evidence.
No.
But what you're proposing is that
there is a fundamental flaw in the system in that the enforcers of animal cruelty laws don't have those kind of sort of surveillance powers that would enable them to obtain that evidence legally.
So you're proposing that if they had reasonable suspicion, like a police officer may have reasonable suspicion of a crime being committed, they'd be able to request a warrant to get that surveillance.
That power already exists, so it would be that sort of stage in an investigation. So where there may be a tip-off or more sort of concrete evidence may be required, giving a private charity enforcement powers, but not the enforcement powers that the police officers have, so our regular law enforcement officers, means that in some circumstances they cannot obtain the evidence that is required to successfully prosecute. And so we've seen the High Court just handed down its decision earlier this month in Gretchen Kadir and ruled that the evidence that was obtained by the covert surveillance was not admissible.
So you want them even
So fundamental justice could be denied.
Before the warrant process, you want them to be able to go and get surveillance?
Well, no more than what police officers can do. It would just be that. It would be sort of giving them,
Devices Act.
giving them no greater powers than other enforcers of criminal laws.
I just wanted clarity around that because the way
so it's not suggesting anything radical.
The way it was phrased, it sounded like
No.
you
So
throw the
just-
rules of evidence.
yeah.
So if I may also add, we also state that fairly clearly at page 6 of our submission, so we just echo what's in that submission in terms of the powers that we would want and why.
Thank you.
Can I just come in there on the back of that? But
Sure.
ideally, you don't want the RSPCA
No.
or AWL to have those powers.
No.
You prefer this to be done by a unit of the police or an independent
Yes.
statutory body. That's
Yes.
really where you're coming from.
That's right. So it's highlighting a sort of a flaw in the current system.
Understand,
Yeah.
but that's a technical flaw, but it's not really what you want to see happen. You really want to see it reviewed.
That's right.
and
How
reformed.
how would you overcome what's been told to us in hearing yesterday about that the police don't have, I guess, the technical knowledge about animal welfare, and they defer to people like the RSPCA and the Animal Welfare League for that technical knowledge about agriculture and animal welfare. How would you see this specialist unit of the police, let's call it ACU, Animal Crops Unit, how would you see them overcoming that?
Just the way any entity would overcome any skill sort of shortage, and that is you just undertake training. You would, undertake training, and it's all about skills, capacity building, and building that expertise. Where we do it, I'm sure you do it. Any entity engages in that kind of capacity building process.
I'd only also add that the RSPCA mentioned in their submission they do have close collaborative interactions with police as well, which does and can include training, so it wouldn't be completely unheard of, or at least unusual if it were even the RSPCA that were to train police in the relevant subject matter.
Which already occurs.
Yes, exactly, as they've stated.
Are you aware of any undercover surveillance evidence that's been obtained by the RSPCA or the Animal Welfare League?
Well, the Kadir case, I think.
No, it wasn't obtained by.
It wasn't obtained
So-
by the RSPCA, sorry.
No,
So actually, the RSPCA have installed
no, I'm not
via
aware
a
of
warrant, seeking a warrant, or have exercising their powers to install. Okay.
Not to our
Are you aware of the police doing such a thing?
I'm not aware of any, but that's not saying much at all, actually.
So are you aware that the unlawfully obtained evidence of live baiting in Queensland and New South Wales led to a major police task force which used the unlawfully obtained evidence to navigate their way to find lawfully obtained evidence? Is that the case? Are you aware of that?
Is that referring to the case we've been just talking about?
So is that Gretchen Kadir or?
I'm not sure, but it's the cruelty charges that were laid against people both in New South Wales and in Queensland in relation to live baiting and other practices in the greyhound industry.
Sounds like that case.
Yes, I'm just not aware of the details.
Would you like to take that on notice?
Yes,
Yes,
thanks.
thank
Mr. Pearson.
Mr. Secord?
Yes, hello. I'd like to get sort of a bit of a context from the Animal Defender's Office.
Sure.
So how do concerned individuals come to you and point out cases of animal cruelty that they would like to see pursued, or do you just simply do research in areas of law, and in fact, in the past, have you assisted the RSPCA?
So pretty much yes to all of the above. So we provide all our services pro bono.
Yep.
We're an unfunded 100% volunteer-based community legal centre. We operate nationally. and so we will assist people, but we don't have enforcement powers under any Animal Welfare Act. Yes, so if people were to report cruelty or instances of cruelty to us, we would do what, for example, we did in the Yass truck crash case, and that is that we could assist them, if instructed, to assist them in compiling a complaint, and there we might be able to offer our, we know the legislation, and assist them in that way. Often we will get the case, I think what you just heard in the previous from the previous witnesses, and that is where people have tried reporting cases to enforcement agencies and for whatever reason haven't been able to get anywhere. There's been no action.
Okay, so that's where I want to go to. So do you find yourself in conflict with the RSPCA, not wanting to take up cases or pursue matters that you think that in fact there's a strong case for?
So it's a very relevant question, and we always have to be mindful as a community legal centre about potential conflicts of interest.
Yep.
And so our starting point, our premise is, our policy is that we won't take on cases where the RSPCA would be the other party, and that is because our interests are aligned. We're both about protecting animals, and we're both about ensuring that perpetrators of animal cruelty are prosecuted. Yep.
Yeah, I see.
So, however, there are instances where the relevant enforcement agency may not have or for whatever reason, either they have investigated. So I'm thinking, for example, of that the well-known case of the bird, the cockatoo kept in the car sales yard, Toyota.
Oh, yeah.
Yeah, and that's an unfortunate case where apparently the relevant enforcement agencies under the Animal Prevention of Cruelty to Animals Act in New South Wales did inspect, but because that very sad situation for that bird did actually meet the rock bottom standards in the relevant codes of practice, there was nothing they could do. However, we did try to assist the member of the public who came to us in complete despair because it seemed that the regulatory framework could not assist this bird, and so they came to us because they'd already tried going to the standard or the enforcement agencies but couldn't get anywhere.
Now, it's been put to the committee that the RSPCA have been accused of taking on matters that have attracted high-profile public interests to curry favor or excite people who have given donations to them. High-profile cases. Yeah. So you're nodding agreement. So what have you found?
I've heard of it, sorry. Yeah.
You've heard of it, yes. Do you have concerns about that? Have people expressed concerns that they're going after sort of the low-hanging fruit or situations that attract a lot of interest and ignoring others?
Well, I think the way the current framework is set up, it unfortunately leads to the perception that could be the case. And that's the problem, that there is the perception that because the enforcement agencies rely on private donations, that could affect, consciously or otherwise, their prosecution policy, for example. Or, for example, they wouldn't investigate enterprises associated with donors, or they would investigate the fluffy sort of cases with a lot of public appeal and not the ones against, say, animals who don't have that public appeal, for example, because it's less likely to result in donations. I mean, I'm not saying that that's the case, but the perception is that could be the case, and that is a fundamental problem for the administration of justice.
We've also heard evidence come forward over the last couple of days, or accusations that there's a disproportionate focus on companion animals rather than farm animals. Is that something you've also heard of or seen? And if you think that is the case, why do you think that would be the case?
Certainly whenever we have been able to find statistics or provided historically or more recently on animal cruelty prosecutions, it seems to be reflected, at least in the raw numbers, that a higher number of prosecutions do appear to be dogs and cats, and lesser so for other types of animals. Were you also asking why we would think that would be the case, or
Yeah.
I mean that could be really hard to truly determine, and it would probably be one that those organisations would be better placed answering. It could be for a multitude of reasons, both.
Could I just ask a question which goes directly to what you're asking?
Sure.
Just a quick one. In the situation where there was a truck that overturned near Yass with animals on it, what species were they?
They were day-old chicks. I understand they were broiler, to become broiler.
Okay, and your
chickens.
evidence was that quite a bit of evidence was gathered lawfully, photographs, videos, etc., correct?
That's correct.
Okay,
Yep.
and it
it was
was
100% lawfully gathered evidence.
Okay, and it was given to the RSPCA to investigate?
The evidence itself, I can't remember now. It may have been links to, because it was already on social media, etc. Because it consisted of video
Part
footage.
of a formal complaint to
But the
RSPCA.
formal complaint, which was several pages long, citing chapter and verse of every bit of relevant legislation and codes of practice, certainly would have made reference to the kind of evidence that was available, being statements from witnesses, photographic evidence, video footage.
So that brief, the RSPCA had received that with a request to investigate.
Definitely.
And so far you haven't heard about anything that's happened, what the consequences?
So we did we followed up on it at various points because we're very conscious of the statutory time limits being 12 months, which is too short. And when we didn't hear anything as that deadline was approaching, we did follow up. And unfortunately, we did hear back from the RSPCA, who was the relevant enforcement agency in that case, and were told that by someone quite high up that they did not know why the investigation had not proceeded, and that they would get back to us, and that's where communication just ceased.
And the statute of limitation has passed?
Passed.
Okay.
Sorry, could I-
If the animals were kittens and puppies, do you think it would be a different response?
Well, that's a hypothetical that.
Yes, it is.
I
and we
mean,
can do
so
that,
if
yeah.
you were to go by the statistics that the RSPCA does itself publish, one would it would not be an unreasonable suggestion to suggest that yes, it may well have been a different result.
Thank you, Ms. Hurst. Sorry for the interruption.
Sorry, could I just going back to, you mentioned some data, Mr. Sayedi, about that you may have compiled around what prosecutions were taking place.
And-
Could I ask you to
And
put on that?
those organisations, those charitable organisations have previously supplied that.
Okay,
data
so
as well.
it could come directly from them rather than putting
That's
it on
right.
notice with you guys? You haven't got extra data that could be
no,
useful?
No.
Okay.
And
That's
it
right.
is useful because it shows that a tiny fraction of the prosecutions are about anything that could be regarded as an agricultural animal, and yet the numbers of agricultural animals, as we know, far exceeds companion.
Just
What do you
following
think-
on, this is directly related to that, if that's all right. So in your submission, you refer to the data. Obviously, there's one issue around the RSPCA not putting forward, I think it was prosecutions by animal type. And so you're using 2011 and 12 data because you're saying that is the most recent.
At the time of our submission.
Okay, that's fine, which obviously wasn't that long ago. But 2011-12, you're saying that only 9% of the total prosecutions were for livestock, which were 24 prosecutions, yet the largest number of animals used by humans. I just wanted to tie it in with DPI, and we heard from the New South Wales farmers earlier today. Do you believe that an approach should be different for farming operations for when we can implement the stock welfare panel, because of the complexities? They're very, very large industry, and it's not going to get shut down anytime soon. So do you think it should be dealt with differently to companion animals?
So to begin with, you've mentioned stock welfare panels. There already is legislative provisions that empower inspectors to enter upon any commercial premises, not just unreasonable suspicion, but merely to ensure that the POCTA Act has been complied with. There's no notice requirements or requirement of a warning to do so. So even for inspectors, we're available to exercise that authority to do routine inspections, as would be expected of many other industries, would be a good start.
Do you think a LLS officer or a officer of a department of the Department of Primary Industries would be better suited to be able to go onto a farming operation and deal with a welfare issue versus someone that's literally going in there to enforce the law and issue a penalty, a notice, or a court order? Don't you think this should be more outcomes based for the animal?
Absolutely, but we would argue that you would achieve that by not having an agency or inspectors or authorised officers associated with agencies whose primary concern is in fostering animal industries.
Okay, Ms Hurst, you may continue now to the
Thank
end.
you.
To
Thank
finality.
you, Chair.
I was on a roll.
How do you think that the enforcement of animal cruelty in the commercial agriculture sector could be improved, given what we've all been talking about?
Independent office.
Leading the witness, Your Honour.
Any of the suggestions that have been made for an independent, and we heard, I think it was the Honourable Mick Veitch's comments about independent doesn't mean not government, obviously, but any...
Not executive,
any agency that could be viewed as independent from industry. So be it either a specialist unit in the police force or an independent authority in that sense, and not either an officer associated with a department whose primary purpose is to work within, encourage animal industry or ensure profits for the animal industries.
And just on a pragmatic level, since, as we mentioned, there is already existing provisions allowing for inspections of these properties, it would be for there to be a sufficient amount of inspectors in whatever body that is to be able to conduct routine unannounced inspections of properties, because it is quite low at the moment.
I've just got one other question in regards to private prosecutions. So prior to 2007, private prosecutions were available under POCTA, and then that was removed. Do you think it would be an improvement on the enforcement of animal cruelty offences in New South Wales if we were to go back to allowing for private prosecutions under POCTA?
Definitely. If there were to be only one change to the current framework, then it could well be that. In other words, we already have the acts or the laws being enforced by private charities. There's no reason why, sort of objectively, that couldn't be opened up to allow private prosecutions. And we're talking about prosecutions, not investigations. So prosecutions to occur.
How would that work?
The same way they do in most other criminal jurisdictions.
So private citizen A can take private citizen B to court for smacking their dog.
Well, that's a civil matter. So, so other jurisdictions, even in the animal welfare space, so ACT, Queensland, Tasmania, and I forget, maybe South Australia, or they have allow public prosecutions, and I think
Criminal offences by private citizens.
So even under the Criminal Procedure Act in New South Wales, the sort of default position is that there can be what's known as a common informant. So anyone can bring a criminal prosecution unless there is a statutory prohibition. And under POCTA, we have a statutory prohibition which limits the persons who can bring, or the entities that can bring, a prosecution.
It's not unusual at all in the criminal jurisdiction for that to be available. We're not suggesting that those should be the majority of those being able to do those prosecutions, but merely that it's not shut out from other entities to be able to do so. This isn't in New South Wales, but just to try and use a tangible example, I recall in the media, maybe mid to late last year, a woman who in Queensland had suffered significant domestic violence, and there was a lot of evidence by, according to that article at least, by the Queensland Police's own admission, available for there to be a successful prosecution, but they decided not to prosecute, and so that individual decided to initiate a private prosecution to do so themselves.
So the avenue is there. Ms. Abigail Boyd?
Yeah, so just following on from that, so just to be clear, if a prosecution was allowed by any private individual, it would be I guess, the burden of that individual to gather their own evidence and to present that case.
Not necessarily. So allowing private prosecutions doesn't actually go to the investigation side of things. They're actually complete. They can be separate processes. So in other words, that's just to stop the sort of alarmist. If we allow private prosecutions, as was the case and as is the case in other jurisdictions in the animal law space, it would mean we'd have every sort of vigilante running onto farms. That's not the case because it actually doesn't affect who can investigate.
We could provide this on notice as well, but there are existing legislative frameworks that allow for private prosecutions, but usually a fail-safe to ensure that it's not just a bunch of individuals initiating private prosecutions, where usually the Office of Public Prosecutions or DPP could at any time take over the prosecution and decide to either proceed themselves or withdraw it. So usually there would be some sort of authority there.
Okay,
Yeah.
and would it be?
Yes, we'd be able to provide that.
Would that opening up again of the private prosecution ability, would that need to be coupled with some sort of GIPA or something that would allow people to get that information from investigations out of the RSPCA or the AWL? Is that kind of envisaged in that?
It would, as the Honourable Ms Hurst mentioned, it was the case in New South Wales that they happened then. That's right, yeah.
It would be helpful, but not necessary.
And that's right.
Yeah.
Yes, and some very sort of good and interesting cases, more along the lines of test cases, were brought, as I think we detailed in our submission, including the Anna the elephant case.
Sorry, go. You can go. I had one final question, but I'll let you answer that first.
It's also not to suggest that private individuals should be given more powers than they would normally have in order to be able to do so. It's just to merely allow the prosecutions to occur in the first place.
My final question was just in relation to the statutory time limitation of 12 months, which, as you said, is sort of way too short. What would you suggest it be extended to?
Well, we just need to go over the border to the ACT where there is no time limit.
But we don't. Sorry.
We can highly recommend it in the animal welfare space.
Please, reality.
Sorry.
What's the statute of limitations there?
There is no limitation, basically.
Okay.
Yeah.
Okay.
That says it all.
May I ask?
And I'll ask Christian.
And once again, the courts are not clogged with sort of ancient animal cruelty prosecutions.
What would,
Government area, let's keep it at that.
if we weren't going to have a no limitations, what would be the next best thing? How many years would be a standard across?
Well, that should, I would defer to, I'm sure there's been some academic research into that, because what you would want to do is look at the kind of cases that have been frustrated, that could have been success, or, prosecuted but for the statutory time limit, and work it out from there. But you'd want at least 3 years.
While still preserving the rights of defendants and relevant safeguards there, of course.
So as you would be aware that this is a fairly, this is novel to Australia to have this inquiry into the enforcement of the relevant animal protection legislation. But there has been overseas, are you aware of where the animal protection enforcement has moved to either the police or an independent authority? From the equivalent of the RSPCA, are you aware of any situations internationally where that's occurred?
So we do refer to it in our submission, but we just didn't go into detail because we assumed that everyone else would.
Sure. But my question is, in that when you did research that, were there any situations where the charitable organisation collapsed, became irrelevant, was no longer an entity?
No.
Okay, thank you. Mr. Secord.
One last question. Now, there's been some concern expressed from previous evidence that there was concern about the RSPCA being a law enforcement, having a law enforcement role, but then, on the other hand, providing a tick of approval or endorsing certain products. How do you feel about that, products and services?
Well, I think it might go back to your earlier question, and that is that would just be another situation where it could lead to the perception of some kind of conflict of interest or bias in how law enforcement duties or functions are undertaken. In that, you could, in general speaking, hypothetically, an agency that has such schemes may well be reluctant to investigate any allegation of cruelty where those in those enterprises that participate in those schemes, because it would reflect badly on the scheme, and so you could understand that at least would be a perception of.
Sorry, would you like to add something?
Just quickly, but more broadly, that just goes to the more fundamental issues of law enforcement being done by private charities who are dependent on donations for a lot of their operations, more broadly.
And do you think the RSPCA could exist if the role of animal welfare was given to an independent body, or would we see the RSPCA evaporate and disappear?
Well, so if the law enforcement part of it, so I think from there and
About everything.
No, I'm just talking about
so the law enforcement, that's what we understood, yeah. So, and here I would be speaking as just a member of the community like anyone else, looking at the data that the RSPCA, for example, provided in its submission, and the money spent on the inspectorate is a small proportion of the rest of their budget and functions, and so one could just look at that and say, well, one, I don't understand why you wouldn't be glad to have that taken away from you, that particular function, but there is a huge range of functions that on paper they could perform and continue to perform and hopefully continue to attract donations, operating shelters, education, rescuing.
So in the RSPCA's own submission, they detail quite a lot of the work that they do outside of the inspectorate, and the overwhelming majority of their staff aren't inspectors, and there's a lot of work they do outside of the inspectorate. This isn't the RSPCA, but just referring to approved charitable organisations. You've heard yesterday from the Animal Welfare League, who themselves said that if they were to lose their inspectorate powers, they would continue doing what they do and continue advocating for animals and doing so to the best of their ability, and that wouldn't change. So we would echo that would, in our view, be what would occur.
Thank you.
I just want to go back to my questions around the GIPA arrangements and the need for that for AWL and the RSPCA. Have you ever tried to access information from the RSPCA or AWL?
No.
Not directly to the RSPCA, not a request for information.
Mainly because our understanding is that it doesn't apply to private charities.
And academia have previously stated so as well, so we operated on that basis.
Yeah, okay, because I will explore this with the RSPCA when they come.
Yes.
Certainly.
Yes.
So
Our interpretation of the GIPA Act is that it doesn't apply. They can voluntarily subject themselves to it, which is great, but equally they can exercise the discretion not to.
And we note the New South Wales...
Sorry, if you could just clarify something there. In the RSPCA submission, they actually do, their evidence
we read
is that the inspectorate body, because it's appointed by the government, is GIPable.
So
Do you agree with that?
If you read that provision in full that they cited, I believe it's Section 2 of Schedule 4
to the Act.
of the GIPA Act. If you read that provision in full, it's referring to that the entity itself has been created by an instrument, not merely the function that has been created by an instrument. And we would consider that the inspectorate isn't a separate entity to the RSPCA as a whole, and the RSPCA hasn't been created by legislative instrument or by legislation. They are a private entity. We would just also refer you to there was another section.
Subsection 3, but I mean this would be a matter of legal opinion, and obviously getting the full details. We're not privy to the full details of how the inspectorate is set up. Or
The only other thing we would add is the New South Wales government in their own submission state that RSPCAs are not subject to GIPA, and we would consider, as it is their legislation, that they would have have the most expertise as to who is
Okay,
subject
but
to
what
that
would be
legislation.
gippable perhaps then is a report from the RSPCA to the minister, and the GIPper would apply to the minister's the documents within the ministry if that report was
Yeah,
sent. Is that
the-
correct?
The other way around.
Not the other way.
The other thing that we noticed as well, sorry, just to go back to the issue, is that we had a quick look but couldn't find. I think agencies are required to report to on their GIPA functions or requests, and we couldn't find one from a prevention of cruelty to animals.
And can I just say, the other thing I just want to say is the Chair's used a word which I know is not going to be in the Macquarie Dictionary, and the Hansard are going to have a distinct difficulty in transcribing, but I've yet to find the word gipperable in the English language. So
It's gippable.
yeah. So, I want to see how it reads in the transcript.
I'm sure it'll be gorgeous. Thank
We
you
look
very
forward
much
to
for
it.
your
Thank-
evidence.
thank you so
Extremely
much.
helpful. Were there any questions that you? I think there were questions you
We
took on
have taken
notice.
questions on notice, yes.
Yes. So you have 21 days to provide that information. Is that okay?
Yes, that's fine. Thank you.
Thank you very much.
Thank you very much.
Thank you so much.